I am going to talk about the title of my talk is Justice is a Numbers Game. My name is Priyangee. You can call me Pri. I'm from India. I am a disabled woman. I am a lawyer, a researcher. I also sometimes moonlight as a comedian. And I love data, like all of us here. My interest in data sort of was ignited when I faced with the big challenge while representing victims of violence. I could feel that some things were not going as per the letters of the law intended, but I did not know if this was a feeling in the gut or a fact. So this led me to documenting and looking for patterns in the data, and the rest, as they say, is history. I personally I'm not a big fan of surprises, so I'm going to lay down what the structure of my talk is going to look like, just to give you a brief overview. I'm going to be spending about 2 minutes on discussing the scope of the presentation, followed by a 7-minute conversation on law and 7-minute conversation on law vis-a-vis data, and then wrap it up. And then we will hopefully have a few minutes to spare for questions. Now, when I was planning for the topic, I struggled a little bit on which aspect to focus on. And that is primarily because each layer had a lot of nuances that we couldn't cover in 20 minutes. So today, my primary focus is going to be how to make justice accessible for marginalized community with the help of data. And this conversation is going to be based on my casework experiences and research experiences. Most of my casework experiences have been working with victims of violence, primarily sexual violence. I will not be talking about the facts of the case to avoid triggers, but that is what I'll be basing my conversation on. Now, why did I decide to even think about this topic? Why is this topic so important for me? Primarily because I think that as a person in a day-to-day life, we engage with law every day, from the time we wake up till we go to bed, whether it be the traffic laws or family laws or banking or commercial transactions or our interaction with neighbors. We engage with law knowingly or unknowingly, and law of the land, knowing the law of the land is a compulsory thing. Ignorance of law is not an excuse. Now, despite that, even as a lawyer, I have often found these institutions inaccessible in the best of circumstances, even when it isn't adversarial in nature. For instance, in India, most government notifications are pictures of scanned documents, which means that they aren't screen reader friendly. And sometimes even court judgments and orders are not screen reader friendly. Sometimes statutes and, not sometimes, all the time, statutes and rules are written in convoluted, long, passive voice that can make any person's head spin. Every word in that book can be metadata in itself. You can take one sentence and write a thesis on it. Sometimes a conversation as simple as who is a child can be a 10-page document, if not more. Sometimes even the premises are inaccessible. There was a recent research that was done which showed that some of the Indian district courts do not even have toilets for women. Which means that as a person, if this is the entire population, unless you are a non-disabled person who is cisgendered and heteronormative and a man from upper caste, upper class community following majoritarian religion, the system is primarily inaccessible for all of us who does not fall under that small minuscule fraction. Now, when I say the phrase minuscule fraction, I would really urge you to remember that phrase, because that will be a very common theme in my presentation, and you will see why. Now, in that statement, like I said, we have excluded majority of the population, and we are talking about minuscule fraction, which also means that law is also an extremely expert-driven process where people whose case is being argued often have little or no say in it. This is all fine when you are someone who wants an expert to create an ironclad agreement or contract and do the negotiations, and you can actually afford to hire a lawyer who will represent your interest. But today, in today's context, in my talk's context, we are not talking about that subsect of people. We are talking about a person from marginalized community. We are talking about someone who needs professional help to represent the very fundamental right to exist freely, independently in a caring world. We are talking about, say, for example, someone who has escaped hostility and is seeking asylum in another country. We are talking about a person who wants to transition to that gender and has been facing several bureaucratic and legal challenges. We are talking about a person who has been abused at home and is in need of shelter. We are talking about a child who has been sexually abused by their father and needs protection. This is the community we are talking about here. And we are talking about those whose identities lead to barriers in accessing basic fundamental rights because of systemic biases and prejudice. Now, but how can law help? They say justice is blind. Blindness here is used as a metaphor primarily because in a non-disabled world, most disabilities are only worth being a metaphor. But I digress. That's not the point. The point is justice is often called blind, but this blindness is different from love is blind kind of way. That is not the same blindness. Here, when people say justice is blind, they mean justice is unbiased. It means that it cares not who you are, where you're from, what you do. And now I think I'm singing a song. It only focuses on the current act and the law in force at the time that governs the act. The justification is that it wants to treat everyone equally. Now, that is problematic in many ways, more than one, primarily because a person is not a two-dimension and we are not devoid of our past. If you really want to know more about this particular problem, I would strongly urge you to read about restorative justice. There are many literature on it, even small snippets of literature. But today, let's focus on identity. Telling people justice is unbiased and cares not what your past is leads to an erasure of past and current experience of a person. It is like telling your employees, I do not care what your disability is. I treat you equally, so I expect equal work. And we all know that happens. That has happened to a lot of us. Now, what is when they say that law wants to treat everyone equally, what does equally actually mean? Now, in the making of Indian Constitution, this particular word has been debated extensively. And the makers of the Constitution has referred to the then existing constitutions as a literature review. And they came to the conclusion that the phrase equality before law does not mean equally. It actually means equity. It equally does not mean treating everyone equally. It means treating equals equally. It acknowledges that some people may be more vulnerable and therefore need extra protection from the state. For instance, the state must protect the LGBTQIA community from violence and also provide them with an environment where they can live peacefully. In this particular context of law, why should we look at data? That is, and now let's carry forward the example of LGBTQIA community. Until recently, India, in India, same-sex relationships was criminalized. And when the case for decriminalization came before the Supreme Court for the first time, the court interestingly noted that the court dismissed the petition and then noted that this was because among other reasons, the court was dismissing the petition because this was about a minuscule fraction of the country's population, and therefore it wasn't a concern that a constitutional court should be looking at. Now, it is very important that now we are talking about law in the context of data. Finally, in this case, they had submitted volumes of data which the court did not look at. This documentation was gathered for about 30 years. And the judge stated how they did not know any gays. Okay, then. The reason why we are talking about it is because this is not an anomaly. This is the norm. And democracy, election, capitalism, etc., actually encourage and foster leaders to follow this as a norm, because they follow utilitarianism to the core, where they follow maximum good for maximum number of people for election and vote bank. But here's the thing: when the Constitution was written in 1950, I'm talking about obviously in the context of India, we knew that this was going to happen. We foresaw this when India wrote the Constitution so many years ago. And I mean, not particularly this particular situation. We foresaw that one day a minuscule fraction of a community's existence will be in threat. So we had provisions for the protection, whether it be gender, sexuality, religion, caste, because the state will otherwise never have that incentive to protect the minority. Now, these provisions were made to undo the historic wrong and to erase the systemic bias in the system. Now, despite the best effort, even today, majority of the powerful positions, whether it be police, courts, and lawyers, are dominated by privileged backgrounds. They do not know they do not understand the background of those they can't relate with because they do not know them or they do not want to know them, and which inherently brings in an inherent systemic bias in the system. Now, how can data help? Again, going back to the people that we were talking about earlier, the person seeking asylum, the person trying to transition, the person trying to escape an abusive home, the child trying to be protected from being sexually abused by their father. When we look back at this subset of people that we are trying to represent in a justiciable manner, we can argue that they all can be, in some way or the other, considered minuscule fraction. But can we let status quo continue? If not, how can we help them? What steps can we take? How can we predict the authorities will act? Sometimes we will not even know who the person in authority will be. As a lawyer, when I'm presenting the case, I will not know the judge personally, but chances are it will be a person who will tick most of the boxes of privileged identity in that jurisdiction. For instance, in India, it's highly likely that I'll be presenting a case in front of an upper class, Hindu, cishet man. We still don't know how the case will go, but as a wise man named Sherlock Holmes once said, while the individual man is an insoluble puzzle, in aggregate he becomes a mathematical certainty. You can, for example, never foretell what one man will do, but you can say with precision what an average number will be up to. Individuals vary, but the percentage remains constant. Therefore, while it is true that we will never know while presenting a case how the case will go, when we have aggregated the data, we can all see a pattern. And when that pattern emerges, we can then predict what the future cases will potentially look like. What does that mean? It means that if we have data in similar cases, we will know what the fixed set of outcomes look like. If we have data with reference to particular judge or officer, we can predict what the response will look like. If the procedure followed is not fair, if the legal provision is not fair and does not take into account the lived experiences of the community it is supposed to protect, we can use that data to advocate for long-term and short-term policy changes at various levels. The possibilities are endless, but how and where can we get this data from? The other F word, I call it, the feminist data. Most data collected vis-a-vis the justice system in India comes from, especially the criminal side, comes from the National Crime Records Bureau. And it is a yearly report which the government collects, and it's quantitative in nature. And there is usually an attached analysis of that quantitative data. This is supplemented by data collected by nonprofits and universities. And some of the data that they collect are collected with the help of the right to information laws. Some of them are collected through interviews, and some of them are a compilation of their own casework. And this is a mixed methodology where they use a bit of quantitative data and a bit of qualitative data. And this is crucial because unlike the government report here, there is a scope to document voice of the people. And yet, in between the two types of data that I have rather broadly listed in front of you, a lot of information and knowledge falls between the gaps. And that is because when it comes to government data, it is collected internally. The government is collecting data that assesses the government. It is true that while it is true that numbers do not lie, but the interpretation and the conclusion can be vastly different depending on who is doing the interpretation. We have to focus on how it is collected and what numbers we are not looking at, along with the numbers that we're looking at. Besides, the data being quantitative misses a lot of information that, for instance, it barely focuses on victim experience. It also misses the intersectionality data. For instance, if a person is attacked, it does not list whether the attack was because of their identity, or if a person is sexually abused, it does not list whether it was because of their other identities like gender or sexuality. And this is not just for victims, even for accused. A recent a research wing in National Law University, Delhi, have been researching on how death penalty has been meted out to people who are from lower caste and who are vulnerable. There's an inherent bias in sentencing, and yet this particular information often gets ignored, and politicians continue to advocate for harsher sentencing because that's a sexier political statement than addressing the root cause of the crime. Now, it is not just the government report that is being problematic. Even reports by non-profits have similar.
Excuse me?
Yeah?
I was just going to say you have 1 more minute.
Right.
So just so you know.
Can I get another extra minute, please?
Yes. 1 more.
Okay. Now, for nonprofits, we have to be mindful of the funding, because the government has been putting a tight leash on foreign funding, and therefore it makes the organization vulnerable to making reports that may be supporting a particular line of agenda. And in the absence of requisite data, it is very easy to sit in an aircon room and say, well, no such thing exists. However, we know that that is not true. Now, in conclusion, I would like to say that accessible data and data interpretation helps in making mythical justice more tangible, but at the same time, we also have to understand that what justice means to one person may not be the same to another. In that context, we should ask several important questions like, how do we structure this data? Who facilitates the collection of the data? Can we decentralize the data? Can we, when we decide to include some data to the exclusion of others, who are we consulting and who are we centering? And how do we make sure that the data represents all experiences and make sure that the systemic erasure does not continue?
Thank you.
We have to make sure that we collaborate with universities and decentralize. In order to get decentralized data, we have to decentralize the resources and help grassroots organizations which do not have resources to collect the data and help them collect the data so as to facilitate a more decentralized collection of data and more accessible justice. And to end it all, I would like to say that as long as we center the community and we are centering care, I think we can help use data to help access justice.